So next we're going to talk about filing your eviction petition. So the costs for filing an eviction petition will vary depending on the county where your property is located. Now it's important to know, number one, where you're filing with regard to the justice court. The county, the cost is going to vary anywhere from $121 in Tarrant and Harris County, as high as $136 in Dallas County. Now this is for one defendant. If your lease has 3 parties listed as tenants, all of whom remain on the premises, you're required by law to file and include each of those tenants if you're demanding possession from the 3 of them. That will increase your costs. In Harris County, that's generally an additional $75 per additional tenant. So the $121 fee that you pay to start only includes the 1 tenant. You would need an additional $75 to serve the second, and then another $75 to serve the third. For advice on precisely how many tenants you'll need to serve, you'll probably want to consult an attorney if you are unsure. You don't want to file a petition incorrectly against only 1 or 2 tenants when all 3 need to be mentioned in the lawsuit. Now, it's important to know what the law requires with regard to your eviction filing. Chapters 24, Chapters 91 and 92 of the Texas Property Code are what are involved, as well as Section 510 of the Texas Rules of Civil Procedure. If any of this is confusing to you, believe me, it's confusing to attorneys too, or can be to someone who doesn't regularly practice landlord-tenant law. If you have questions regarding the specific implementation of Texas law in a landlord-tenant matter, it's not a good idea to consult a general attorney or someone who practices essentially in other fields. Because the laws are so narrow, it's always best to consult an experienced real estate attorney, particularly a real estate attorney who has some experience and some focus in landlord-tenant law. Again, if you have any questions, feel free to reach out to us and we'll be happy to answer those questions for you. Now, choosing the right court has to do entirely with where the property is located. And so if you are in a large county like Bexar County or Tarrant County or Harris County, you're going to find that there are multiple justice courts. And the law does not accommodate the landlord. The law accommodates, in this case, the tenant, particularly where the property is located. So if you reside in Fort Bend County, but your property and your tenant reside in Harris County, it's important that you know to file the lawsuit in Harris County in this particular case. However, which justice court do you seek out? Well, you need to know which precinct your property is located. And so that could take some investigation. You may, for example, call a local justice court and say, I'd like to know if this property is located in your precinct. Some courts are more helpful than others. Some counties have websites that can assist you with this process. However, if you are unsure or lost or not certain whether you're filing in the right place, contact an attorney. It's a terrible thing to file multiple times, and I've seen it for landlords to file multiple times, believing that they're filing in the right court, just to find over and over they're frustrated by a process because it is determined later that they filed in the wrong court. Contact somebody who knows how to find the information you need to make sure that your eviction is filed in the right county and in the right precinct. Let's talk about the process itself. If you file a lawsuit in Texas, service or notice of that lawsuit is required on the defendant against whom you are filing. Generally speaking, that notice is sent by in Harris County, a constable. And so in the state of Texas, there are law enforcement agencies that deliver notices from the court to defendants who are being sued. And the same is true in the eviction process. Now, generally speaking, it's a 21-day process from filing to trial. The courts have designed a process that's streamlined in an effort to protect landowners and people who rent these properties out. In many cases, however, the constable will come and knock on the door and be unable to reach the tenant. The court will then have to assign what's called alternative service, and this may extend by some, but not much, extend the amount of time that it takes to get your case to trial. Please understand this is a normal part of the process. The court will allow the constable to deliver the notice by alternate means, which will likely include taping a copy of the notice to the door and simultaneously mailing that copy to the tenant. In this way, the tenant is properly informed of your intent to sue them, what the substance of the lawsuit is, and when the trial date is. Now, please also note that the tenant has a certain number of days to request a jury trial, and often tenants will seek the assistance of a jury trial in order to plead their case to a group of their peers. And sometimes people feel more confident presenting a case to a jury. The unfortunate part for a landlord is it will inevitably increase your legal costs should you hire an attorney to represent you, because a jury trial takes inevitably many more hours of preparation and time in the delivery of your petition to the court. And so if you are in a situation where the tenant that you have attempted to evict has sought a jury trial for your eviction hearing, you likely want to consult an attorney for advice on how to handle this particular matter. Juries can be complicated and can be influenced by a sad story. And so you want to make sure that the court only hears the evidence necessary for you to gain possession and for the default that was committed by your tenant to be front and center, and not some extenuating circumstance that really has nothing to do with the eviction process.